10 seconds, 5 seconds. Start. The non-applicant seems to have prima facie acted in breach of the agreement. The dispute seems to have arisen out of a bona fide arrangement between the parties. The arbitration petitions also seems to have been filed within limitation. In such circumstances, I allow this petition and refer the disputes raised in this petition or any other dispute that may become available to the parties to the sole arbitrator. The non-applicant shall be at liberty to raise any counterclaim if so advised. I hereby appoint Mr. Justice B.P. Singh, former judge of this court, as the sole arbitrator. The learned arbitrator shall be at liberty to fix his own remuneration and any other terms and conditions for the arbitration as deemed fit and proper at his sole discretion. The seat of the arbitration shall be in Delhi. However, the arbitrator may hold the arbitration proceedings at a place most convenient to the parties either within India or outside India. In our country also, when the Criminal Procedure Code 1861 was enacted, it was silent about the compounding of offence. Subsequently, when the next code of 1872 was introduced, it mentioned about compounding in section 188 by providing the mode of compounding. However, it did not contain any provision declaring what offences were compoundable. The decision as to what offences were compoundable was governed by reference to the exception to section 214 of the Indian Penal Code. The subsequent code of 1898 provided section 345 indicating the offences which were compoundable, but the said section was only made applicable to compounding of offences defined and permissible under Indian Penal Code. The present code, which repealed the 1898 code, contains section 320 containing comprehensive provisions for compounding. A perusal of section 320 makes it clear that the provisions contained in section 320 and the various subsections is a code by itself relating to compounding of offence. It provides for the various parameters and procedures. This court, on the basis of the submissions of the learned Attorney General, framed certain guidelines for compounding of offence under section 138 of the NI Act. The court held in paragraph 26 of the Damodar that those guidelines have been issued by this court under Article 142 of the Constitution in order to fill up legislative vacuum which exists in section 147 of the NI Act. The court held that section 147 of the NI Act does not carry any guidance on how to proceed with the compounding of the offence under the NI Act, and the court felt that Section 320 of the code cannot be strictly followed in the compounding of offence under Section 147 of the NI Act. Those guidelines were given to fill up a legislative vacuum.